Good afternoon, everybody. Welcome to today's Notary Public Town Hall. Michael Schlein, I'm the Director of the Charities and Legal Services Division with the Secretary of State of Maryland. Today is talking about allowable actions that a notary public may perform. Before we get started, just cover some basic ground rules here. If you've been on these town halls, you kind of know how these work now. Same setup. We're going to present all this information. If you have questions, feel free to throw it in the chat. Please do not answer questions in the chat unless you are a notary officer that's employed by the Secretary of State. We've had some very well-intentioned folks over the years give sometimes just incorrect or misleading and sometimes really bad information when answering other people's questions. So feel free to ask questions in the chat, but unless you are somebody with the Secretary of State's office, please refrain from answering them at the end. One of our notary officers will read off some of the commonly asked questions in there so we can talk about them. And after all of that, we'll hang on and take some individual questions. If everybody would like to stay on and do that, feel free. That'll come at the end. You might find that your questions answered during the town hall. And like today, we're going to talk about allowable actions, so types of notarizations and material certificates and things of that nature. So try to keep your questions geared towards that. And like, hopefully I answer any you have. And if I don't, bring them up in the chat, ask them at the end. Today's town hall is for informational purposes only. This is not intended to be legal advice. It's also not the course of study. So folks that are around here thinking they can take this to renew, that's not what this is for. This is just talking about one area of interest for notaries public that we get questions about pretty routinely, and just trying to convey some more detailed information and conduct some outreach here to help those that want to learn that information, but it's not the course of study for the purpose of renewing. One other thing I want to throw out too, because we get a lot of questions about it. We can't answer title insurance producer questions. We can't. We're not. Maryland Insurance Administration is who licenses title insurance producers. So if you have a title insurance producer question, please direct it to them. We can't answer those on this town hall. We're not going to. We don't regulate them and can't give legal advice anyway. So keep that in mind. In terms of how this will flow and what information we can provide. So again, being recorded, by joining the recording, you're consenting to participation in this recording. This recording will get posted on the Secretary of State's website on the Notary page, usually within a week or so of the town hall. So by midweek next week, probably earlier, it'll be posted. And you'll be able to watch it at any point in time further. It'll be there. There are other recordings of notary town halls we've conducted over the past several years are posted there. And you can look at them at any time. sos.maryland.gov, SOS like Secretary of State.maryland.gov is the Secretary of State's homepage. And then from there, you just click on the word notaries. It'll take you to the notary page, the landing page for the notary division, where you'll find all kinds of good information, including these town hall recordings. When you have questions, that's probably a good place to start. So again, informational purposes only, not legal advice. Questions in the chat for now, and we'll answer. One of our notary officers will probably answer them as best as she can as we go, but we'll read some off at the end if they tend to be common themes. And thanks again for joining us today, and thanks for your service to the state as a notary public. Notary public is an officer of the state of Maryland. So we appreciate what you're doing and your interest in learning more.
I'm the new Chris Sargent.
So generally, we always start with this slide here first. Sources of legal authority. Maryland Constitution. Notary public, that position's in the Constitution of the state of Maryland. Annotated Code of Maryland, Title 18, subtitles 1 and 2. That's the notary law that we're regulating and we're talking about here today, specifically the sections of the law that have to do with types of notarial acts and notarial certificates, and the Code of Maryland regulations, which are the regulations that further supplement the law that notaries should know. So our information is coming from these sources today. Before we get moving into all the details, there's a lot of links here on this page. You're not going to be able to probably write them all down in time. Again, this recording will get posted, so when in doubt, go back to that recording. But if you remember nothing else, remember sos.maryland.gov, sos.maryland.gov. You can get to the notary page from there, and from that notary page, you can find all of these links and even more information that might be of interest to you. There's a home page. If you're trying to buy a handbook, links to where you can look up the law and the regulations online for free. New notary application info page, renewing information page, frequently asked questions, all posted there on our website from the notary page. You can get to everything here. So just in going over types of notarizations, general powers of a notary, you have kind of throwing it at a very high level, in-person notarizations, right? Your traditional notarial acts, somebody shows up in front of you. They're in your physical presence. You identify them, probably watch them sign something. This is happening in real time in the same room and space. You'll notice a theme for all these types of notarial acts as we go on into this town hall and we talk about different types of notarial acts and their certificates. Every one of those notarial acts requires these 5 things. They require you to be in the physical presence of the signer. You must identify the signer. If you don't know them personally, you need to use government ID or credible witness. You need to witness the signing of the document or somebody attests to the fact that they signed it, depending on the notarial act, and we'll get into that later on. Affix the seal and execute the notarization, complete the certificate. The certificates that we'll cover here as well today, and also make the entry in your Register of Official Acts, which now the law calls it a journal. So these 5 things, no matter what type of notarial act you're doing, you're going to do these things each and every time. And if you're not doing any of these 5 things, you're missing out on it. These are the things that are required every time you're notarizing something, no matter what type of notarial act you're doing in person. Really quickly, covering fees. There's a thing folks call themselves a mobile notary. That's not an actual licensing category. It's not a real thing in the eyes of the law, but it's an industry term that folks use when they travel to notarize. Call themselves a mobile notary. It means they'll go somewhere to notarize, and you can travel to perform notarial acts. You just have to be standing in the state of Maryland at the time you notarize. And you can, if you're traveling to notarize, you can charge a regular notarial act fee, and you can charge $5 plus mileage to travel. We're not going to get into depth of notary fees. If anybody wants a good breakdown of notary fees, the Code of Maryland regulations link I shared has the exact breakdown of fees in the law, but just touching on in-person travel notarizations. Folks kind of get hung up about the mobile notary thing. Like I said, you're just a regular notary, just one willing to go somewhere. It's not something we track or manage, but if you're going to do it, you can charge for travel at the allowed rates. It's not an open market, at the allowed rates for travel. The previous town hall, we really broke down the fees in addition to the regulation where it's found. Break it down in detail, what you can charge for what, and give examples. As one of the previously recorded town halls that's on our website. Electronic notarization. This is similar to in-person, right? It's in-person, but using electronic records and electronic signature and electronic seal. Common term, people call themselves an e-notary. So under our law, you can electronically notarize, and you've been able to do that for a very long time. But electronic notarization still requires personal appearance, same physical place when notarizing. But it's replacing the hard copy record where you're hand signing with an electronic record that you're electronically signing. And then the remote notarization, which became effective in the law October 1st, 2020. Folks will remember some of the temporary emergency orders at the beginning of the COVID time, March 2020, up through October 1st of 2020, where you had those temporary orders in place. The law is different than those temporary orders. It is different. We shouldn't be following those temporary orders anymore, and we should have stopped following them October 1st of 2020. So with remote notarizations, they still appear before you, but through a specifically designed and approved audiovisual technology. You'll hear us in other town halls later this year. We're going to talk about remote notarizations in more detail. We'll refer to those specifically designed and approved technologies as RON vendors. There's electronic document, notarizing electronically. Remote technology allows you to witness that signature being affixed in real time, simultaneously affix your seal. You've heard it called remote online notarizations, webcam notarization. Please mute yourself. Remote online notarization, webcam notarization, online notarization, virtual, all those are remote notarizations, the terms for it. There is something called a remote ink notarization now. If you want details about remote online versus remote ink, that upcoming town hall a little later this year, I want to say it's in November, we'll talk about that in much more detail, remote notarizations. So general powers, those are, you're going to notarize in those three scenarios. More than likely, it's going to be mostly the first one in person and to a second degree remote. But a notary public may perform these notarial acts. We're going to spend a lot more time talking about acknowledgments, oaths and affirmations, witnessing and attesting signatures. But we're also going to touch on, with detail, the certified copy of a record in someone's possession, tangible record from an electronic record, certified copy, and protests we'll touch on as well. I mentioned not too long back, notary public may perform notarial acts really anywhere in the state of Maryland. You must be physically present in the state of Maryland in order to notarize. If you're not standing in Maryland, you can't notarize, right? If you're a Maryland notary public, your authority to notarize is only while physically standing in the state of Maryland. Doesn't matter what county you're in, Baltimore City, any other county. For example, if I'm commissioned, let's say I'm commissioned in Anne Arundel County, I can notarize in Anne Arundel County. I can notarize Baltimore City, Baltimore County, Montgomery, throughout Maryland, right? From the mountains over to the eastern shore, north to south, east to west, anywhere in between. As long as you're standing in Maryland, you can notarize if you're a Maryland notary. Even if it's a remote notarization, you still must be physically present in Maryland. The notary public must be in order to remotely notarize. Doesn't matter where the document's coming from or where it's going, as long as it's being notarized in Maryland. Just a few other points of business here, conflicts of interest. In general, stay away, right? A notary is a disinterested third party that's there to identify folks and watch them execute a document, and complete the notarial certificate. If there's a conflict of interest, you should probably stay away. There's a few instances where you have to stay away. The law expressly forbids you from notarizing for yourself or your spouse. Can't notarize for yourself or your spouse at all. Never, ever, ever, never, ever. I get some good questions about different scenarios, about, well, why, in this scenario, couldn't I notarize for my spouse? Nope, never. Not allowed. Not for yourself either. Even though you're not under a legal duty to refrain from other family members, you should stay away from notarizing for other family members, right? You have a legal duty to refrain from notarizing for yourself and for your spouse. But there's 80,000 notaries in Maryland, you can find a notary that's not related to you to notarize. So again, not a requirement to refrain from other family members, but you should. In a different point in life here, I handle notary complaints, and I don't have specific data to give you, but I could tell you probably half to more than half of the complaints I received were documents involving family disputes, and many of them were notarized by family members. Just don't, right? It's always good until it's not, and stay away from notarizing for family, especially when money and property is involved. Never a good idea, not good to put yourself in the middle of that, and it's great until it isn't. I've seen some pretty sad stuff over the years with regards to families and how things kind of devolve into chaos after traumatic or significant life events occur, and they come back to notarizations that were done by a notary who maybe didn't know all the stuff going on, but just stay away from notarizing for family members if you can. But you must stay away from notarizing for yourself and your spouse. With regard to any other matter that the notary is personally involved, even if indirectly, where there's no beneficial interest, you should stay away. Obviously, you must stay away if you stand to gain financially from the document being notarized. If you have that direct beneficial interest, you must stay away. You can't perform a notarial act if you have a direct beneficial interest. Just kind of running down some other restrictions that I want to highlight. Notaries are not authorized to draft legal records or give legal advice or practice law unless you're a licensed attorney, in which case you're an attorney and you're practicing law as an attorney, not as a notary. Act as an immigration consultant or expert on immigration matters. Can't represent people in judicial or administrative proceedings, right? Your notary public commission allows you to be a notary, not these other things. If you're licensed to do these other things, great. But you have a license to do those other things. You can't just say, hey, I'm a notary, I can do this. Can't engage in false or deceptive advertising using the term notario or notario public unless you're actually licensed to practice law. Those are terms that can be used to mislead people into thinking you're an attorney. And you can't advertise that you can draft legal records or give advice or otherwise practice law unless you are the licensed attorney or under their supervision, and however all that works. But if you're not an attorney or under their direct supervision, don't say you can practice law. Don't give legal advice. You can't do it as a notary public. You got to be a licensed attorney. So after we kind of basic housekeeping here, we're going to get into the different notarial acts and the certificates. The first one we're going to talk about here, or we're going to talk in general about notary certificates first, and then we're going to get into all these specific types of notarial acts throughout the rest of our time here this afternoon. Prior to October 1st, 2020, not every notarial act required a certificate. The law changed significantly on October 1st, 2020. Folks that have been a notary a long time, hopefully been paying attention to that. Noticed a bunch of information we were sending out around that time, and talked about all the new standards and requirements in the law. And now, from October 1st, 2020 through today, every notarial act must be evidenced by a certificate. It must be there. And we'll talk about what to do if it's not. But it must be there for every notarial act. No more just official witness, date, sign, seal, my commission expires. There's an official witness attesting a signature notarial act, but it gets a certificate now. So if you're notarizing stuff and there's no notarial certificate wording on it, you have to know how to add it to the document in order to complete a notarial act. Because if it's no certificate wording, it's not a notarial act under the way the law is written now. So there are examples in the handbook of the different types of notarial acts. Those examples in the handbook are taken right out of the law, which gives you samples of notarial acts. Today's town hall is going to have those certificates right from what appears in the handbook on the town hall slide, so you can get a look at it too if you're not familiar yet with this type of requirement and with the notarial certificate wording. Each notarial act shall be evidenced by a certificate. That certificate shall do the following things, or be the following things. It must be contemporaneously completed with the performance of the notarial act. So at the same time in occurrence. If I identify you and I watch you sign and you're doing an acknowledgement or whatever it is you're doing, and I administer that, I can't wait 3 hours to do the certificate. I need to do it now. It happens now at the same time in occurrence contemporaneously with your performance of the notarial act. It must be signed and dated by the notary. That's right. Signature should generally match what's on file with the clerk when you take your oath of office. It should identify the jurisdiction in which the notarial act is performed. We're going to talk about the elements of that certificate here. Contain the title of the office of the notarial officer. For you, if you're a commissioned notary public, it's notary public. The notarial officer is a notary public. It's going to indicate your expiration date. So if you're a notary public, you have an expiration date. There are certain other individuals that are allowed to notarize that are considered a notarial officer, but not a notary public, who may not have an expiration date. We're not going to cover that really here at all. We're just focused on notary public. So your expiration date should be a part of that notarial certificate. And if it's not, it needs to be on your notary seal, your stamping device. So notary may not affix their signature to or logically associated with the certificate until the notarial act has been performed. So you don't want to fill out a certificate and sign it until you've properly identified somebody. You watch them sign it. You administer the acknowledgement or oath for affirmation. That's when you're going to go about completing the notarial certificate and affixing your seal. You're affixing your seal as part of this notarial act. That certificate shall be a part of or securely attached to the record meaning the document that you're notarizing. Part of or securely attached to. And just kind of some information here as to things I've seen that meet that requirement. Folks, hope in an ideal world, the notarial certificate wording is just a part of the document. You're just going to complete it. In a non-ideal world, which is where most of us live, you may not have certificate wording there. You're going to have to attach the appropriate certificate wording to the document, securely attach. Maybe that's a stamp with the wording of the certificate. I've seen people handwrite it on there. That ink's securely attached to that record now. I've seen people staple it, clip it, securely attached to. That's what the law says. It doesn't go into great detail beyond. It doesn't go into detail beyond that. So just a few highlights of things I've seen that make it securely attached. And what's important here, the certificate wording, the notarial certificate, what makes it the certificate is the wording itself. It doesn't have to be on fancy paper. It doesn't have to be anything fancy. It's the wording itself, and we're going to cover that wording here for each act. The wording itself that makes it the notarial certificate. That's why I say, some of the things people have done to securely attach, stamped it on there, hand wrote it on there, clipped it, stapled it to the record. If a notarial act is an electronic record, the notary must attach the official stamp or logically associated with the certificate. The certificate must be logically associated with or attached. That's fancy wording to cover notarizations on electronic records, many of which will be remotely notarized. So the first type of notarial act is called an acknowledgement. An acknowledgement is just a declaration by an individual before a notarial officer that the individual has signed a record for the purpose stated in the record, and if the record's signed in a representative capacity, that the individual signed the record with the proper authority and signed it as the act of the individual or entity identified in the record. Constituting your act and deed. That's what the signers, I should say, act and deed, whether for themselves individually or on behalf of a corporation or other individual in a representative capacity. So it's not swearing of the truth of something. It's just a declaration that you sign the record, the signer has signed the record for the purpose stated in said record. We're going to talk about oaths and affirmations here next, but that's all an acknowledgement is. What are we doing when we take an acknowledgement? Step-by-step process for completing an acknowledgement. The person making the acknowledgement must personally appear before the notarial officer, whether it's in person or by communication technology. The notarial officer must properly identify the person requesting the notarial act. The notary is recording the details of the act in their journal. Notice that's third, not last. That's on purpose. You've identified a signer. You know what they're here for and that you're going to do an acknowledgement. You have the information now to make a journal entry. Maybe something happens that causes you to not be able to complete the notarial act. Well, now you have a journal entry that you intended to complete one, and you can note why it had to be declined. So journal entry, good to not wait till the very, 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 very end after the signer has everything they want from you. Get that journal entry done before they walk away. It's got to be done before they walk away anyway, but get it done early in the process. If not already signed by the person executing the record, observe the signing of the document. You're going to take a spoken statement of the individual executing the record. That person's making the acknowledgement. They need to state something to the notary public to the effect that the document constitutes their act and deed. That's all. They need to say that, or you need to ask them that, and they need to confirm that. That's an acknowledgement, right? We're not asking them to swear to the truth in this scenario, just that it constitutes their act and deed. And then after they do that and they've signed the record or acknowledged that they already signed it, you're going to complete and sign the notarial certificate on the record. Sample certificates can be found in the handbook. We're going to actually have the sample certificates here next. Then you're going to apply your stamping device to the notarial certificate that's affixed or logically associated with the record. So these are your steps. You have a handbook, they're in there. Refer to them. It's kind of like a step-by-step guide for how to do an acknowledgement. Definitions of acknowledgements are nice, but you know, I like to have a good step-by-step guide. This is that for handling an acknowledgement. Here's a good sample certificate of an acknowledgement for somebody acting in their individual capacity. So I myself am acknowledging something for myself. We'll get to the representative capacity next. Notice that certificate starts with State of Maryland. Every certificate venue should always say State of Maryland. Why is that? This certificate, you're completing it for what is true at the moment in time when you're notarizing. And if you're a Maryland notary acting as your capacity, in your capacity as a Maryland notary, where must you be? Right? We covered that on an earlier slide. You got to be in the state of Maryland. So every notarial certificate's venue should have State of Maryland. Should never say another state. Why? Because if it has another state listed there, it makes it look like you notarized in that other state, which you cannot do as a Maryland notary. Because again, it doesn't matter where the document's coming from or going to. This certificate is explaining what happened in this notarial act. It happened in the state of Maryland. County of, wherever it occurred. Or if it occurred in Baltimore City, City of Baltimore, Baltimore City. This is not necessarily the county in which you're commissioned. It's probably one of the more frequent mistakes I see, or I guess I should have seen in my past life looking at notarial acts and dealing with complaints. Folks will just write the county in which they're commissioned, which may also be where they notarized it, but it may not be, right? So I said earlier, say for example, I'm commissioned in Anne Arundel County, Michael Schlein, Notary Public, Anne Arundel County. If I'm notarizing in Anne Arundel County, it's going to say State of Maryland, County of Anne Arundel. Let's say I'm down at the ocean, head on down to the ocean, and I needed to notarize something while I'm there. It's going to say State of Maryland, County of Worcester, because that's where I was when I notarized. My notary seal says Anne Arundel County, right? It's already on the notary seal. So for your certificate, State of Maryland, and then County of wherever you are located. If you are down in Rockville and notarizing, it should say County of Montgomery. If you're in Baltimore City, it should say City of Baltimore or Baltimore City, State of Maryland, Baltimore City. If you're up in Elkton, State of Maryland, County of Cecil, and so on. I don't want to test my knowledge of towns in every county. I think I could come up with one, but I won't bore you with that. Then the rest of the certificate here is explaining what type of notarial act it was, when it was done, and who did it. This record was acknowledged before me on the blank day of whatever month it is, 2000, whatever the year is, by the name of the person taking the acknowledgement. So if you were the notary and I was appearing before you, this would say this record was acknowledged before me on the 17th day of September 2025 by Michael Schlein. That's all. Pretty straightforward. How do we know it's an acknowledgement? It has the word acknowledged in it. Direct translation, correlation. Acknowledged means an acknowledgement. So the date on which the notarization actually occurred. Don't backdate it. Don't forward date it. Whatever day that person shows up before you, that's the date that goes in that certificate. Whatever day they are completing the notarial, or you were completing the notarial act with them in your physical presence. Or if it's remotely notarized, your remote physical presence. Date, month, year, who took the acknowledgement. If more than one person is taking the acknowledgement, maybe you're notarizing two individual signatures. Both of those names should be in these blanks, or in this blank. Both should be in this blank. Sometimes this comes pre-filled out. Maybe my name's pre-typed there. You don't have to write it in. Great. If there's more than one name pre-typed there, though, but not more than one person is there, you either need a fresh certificate or you need to line through the name of the person that's not there. Right? You can't, if somebody's name is in this certificate and you put your notary seal on there, you're telling everybody that everybody mentioned this certificate was there and you notarized all of their signatures. Make sure they were really there. Then you're going to sign a fixture seal, expiration date, write it in, or maybe your expiration date's already on your seal. Cool. Title of the officer, for everybody on here, Notary Public, a fixture stamp, right? Acknowledgement in a representative capacity, pretty similar looking, still State of Maryland, still going to be the county of wherever that notarial act occurred. Pretty much the same wording as it starts, right? Acknowledged by me on this 17th day of September 2025 by Michael Schlein or whoever appeared before you. And then it might have a couple extra blanks, and this is the information you're going to put in those blanks. Really, if it's in a representative capacity, say I own a company. I don't, but say I did, and I was signing as owner of the company, would be as owner of Mike's company, would be what I'd be putting in those blanks. So this is another good example of a notarial certificate right out of the law, right out of the handbook. Does an acknowledgement have to say exactly this? No. There might be some extra wording in there sometimes. That's fine. It's totally fine. But these give you a baseline of what a certificate should look like. And if you're attaching your own certificate because you have to, it's a really good idea to use exactly what the law says to use. It could be something else that has the same meaning but slightly different wording. But the bottom line is these are the elements that acknowledgement should have. Every acknowledgement should have at least these elements. For the individual capacity, these elements. if in a representative capacity, these elements. But always state of Maryland, always county where you're located when you're notarizing. Some just kind of popped into my brain here. If you're doing a remote notarization, wherever you're standing is what county you should log. State of Maryland, county of, I'm physically standing in Anne Arundel County right now in my office. So it would say state of Maryland, county of Anne Arundel, because that's where I am as the notary, and that's where the person kind of traveled virtually to visit me to get it notarized for a remote notarial act. Next, notarial act, verification on oath or affirmation. It's a declaration made by an individual on oath or affirmation before a notarial officer. The statement in a record is true, or that a remotely located individual has the identity claim. We're going to focus on the statement in a record is true portion of this. So an oath or affirmation, a solemn statement declaring something to be true, a fact, a sworn statement. What are we doing? Step-by-step process right here. Break it down. Looks super familiar to, super similar to the acknowledgement process. Verifying that they are who they say they are, that they have personally appeared before you. Right? They got to show up first, then you got to identify them second. You're going to record those details in your journal. When you're writing your journal, we touched on journal requirements in a prior town hall. If anybody wants to go look at that, or just check out the handbook, does a really good job of laying that out. Every journal entry has to provide the type of notarial act performed. So if you're doing an oath or affirmation, you should note oath or affirmation. You don't have to always write both. If it's an affirmation, write affirmation. If it's an oath, write oath. But indicating the type of notarial act in that journal. So it's important to know the type of notarial act you're doing, not just because you have to ask them something, but because you've got to keep a documented record of that in your journal. And if you don't know what you're doing, it's hard to make a good journal entry about it, right? For an oath, you're going to observe the signing of the document. And I'll explain why in a second, because it's based on what the certificate wording says. You're taking a spoken statement of the individual that's signing that record, that where they're swearing or affirming to the fact that the contents of the document are true, whether that's on their personal knowledge or to the best of their knowledge, information, and belief. A notarial certificate's going to tell you which one. Most of what you're going to see is just that they're swearing to the truth on their personal knowledge, because most certificates are for an oath or affirmation are going to say sworn and subscribed before me, or I'm subscribed and sworn to before me, or subscribed and affirmed to before me. So that's just on personal knowledge. If it said something like subscribed and sworn to on the best of my knowledge, information, and belief, then it's to the best of their information, knowledge, and belief. But does that matter for what you're doing? Not necessarily, other than you're going to ask it that way, right? To the best of your knowledge, or to your knowledge, or to the best of your knowledge, information, and belief. You're going to complete and sign the notarial certificate on the record. Expiration dates, right? Sample certificates found on the handbook. It's going to pop up here on the next page. Apply the stamping device to the certificate that's affixed to or logically associated with the record. Short form certificate for an oath or affirmation. Forgive me for driving this point home. You're going to hear me driving home every certificate. State of Maryland, always state of Maryland, because you're here when you're notarizing. County of, wherever you are located, the time of the notarial act. Signed and sworn to or affirmed before me on the blank day of whatever month of whatever year by the person that's taking that oath or affirmation. Signed and sworn to, or signed and affirmed to, meaning it's signed in front of you. Signed and affirmed, or affirmed and sworn, or signed and affirmed to before me, you the notary officer, on the 17th day of September 2025 by Michael Schlein, right? If I'm the one that you're notarizing for. How do we know it's an oath? It says sworn. How do we know it's an affirmation? It says affirmed. Either way, though, sworn to is an oath/affirmation. If you see acknowledgement or acknowledged, you know it's an acknowledgement. If you see sworn, you know it's an oath. Right? The certificate wording gives it away. Somebody might ask, how do I know which one to do? What if there's no certificate wording? What do I attach? Well, what you attach is dependent upon their request. They need you to notarize and acknowledge, hey, I need to acknowledge this. Cool. They need to swear to the truth of it. Oath or affirmation, right? Acknowledgement, acknowledge it, use an acknowledgement certificate. Swear to the truth of it, oath or affirmation. It's based on their request. Now, if they just come to you and say, hey, I need you to notarize my signature, that's this type of notarial act. Those that have been a notary a long time will remember that if somebody just brought you something without a certificate, you just acted as an official witness. That's what this is. Except now you have to attach a certificate that says you're doing that. Witness or attest to a signature. We're going to talk about the difference here in a second as we go through the steps. And that's really all it is. Somebody's signing it in front of you. You've identified them. They sign it in front of you. They're not making a sworn statement or taking an acknowledgement. You just watched them sign it. That's witness to a signature. Attest. Maybe the document's already signed and they still need it notarized. Well, they can attest to the fact that they signed that to you. Hey, I attest to the fact that I signed this. That's my signature there. That's attesting to a signature. And we'll split the difference on the certificate wording here on the next page. No matter whether it's witnessing or attesting to a signature, though, they need to show up in front of you, right? Personally appear before you. You have to identify them. They have to have the identity of the person requesting the notarial act. You're going to record the details in your journal. So if the document's not already signed by the person executing the record, you're witnessing their signature, you're going to observe them signing the document. If the document's already signed by the person executing the record, you're going to just have them attest to the fact that they already signed it. That's their signature. After one of those two things have happened, you're going to complete and sign the notarial certificate on the record. Sample in the handbook, sample on the next page. Apply the stamping device to the notarial certificate that's on or affixed or logically associated with the record. What's this certificate look like? Right here. What does it start with again? State of Maryland. You're going to be saying that in your sleep tonight. State of Maryland. Forgive me if you do. State of Maryland. County of, wherever you're located. Wherever you are located at the time of the Notarial Act. If I was standing out in Allegheny County right now, it would be State of Maryland, County of Allegheny, even though I'm an Anne Arundel County notary. Right? Signed or attested before me on this blank day, a blank month, blank year by whoever signing or attesting before you. If I'm signing before you, you just need to say signed before me on 17th day of September 2025 by Michael Schlein. I've already signed it, and I'm just coming to you to attest to the fact that I signed this so I can get you to notarize that I attested to the fact that I signed this. The certificate only has to say attested before me on the 17th day of September 2025 by Michael Schlein. Whoever's appearing before you is whose name goes in that certificate. I didn't drive this point home on the oath one, but I'll re-drive it home again. Now it's the same though. No matter what type of notarial certificate you're filling out, whoever is appearing before you and having their signature notarized is whose name belongs in that last blank. If it is more than one person's name should be listed there by you. If it is pre-typed, everybody whose name is pre-typed needs to be there in order for you to notarize it. In a really ideal world, there's a separate certificate for each signer. There's a certificate for, if it was me and Carrie Ann, who you'll get to hear from later when we get to the Q&A. For Carrie Ann and I were before you getting something notarized by you, that certificate, if there's only one certificate and you're notarizing for both of us, needs to have both our names in there. In a perfect world, there's a certificate for every person coming before you individually. Why is that better? Because maybe Carrie Ann made it and you can notarize for her, but I couldn't make it. Right? So you can do the notarial certificate for her, but you can't put my name in there because I didn't make it. Maybe need to get notarized at a different time by a different notary. That's why it's always better if there's a separate certificate for each individual signing it. But again, we don't live in an ideal perfect world. We live in a very imperfect world. And sometimes that certificate's just going to come with one certificate where you got to put both of our names. And that's fine as long as we're both there. So witness or attest. It's as straightforward as that. I watched you sign something and I'm notarizing with that fact in mind. You attested the fact that you signed something and this certificate is verifying that that occurred. That's all that's happening there. Again, it's a sample certificate. If it says something a little extra or different, that's fine. But this is at its core, it should have these elements in the certificate for an official witness or attestation. Certifying or attesting a copy of a record. So what's happening when somebody asks you to do that? You're just certifying or attesting that a copy of a record, is a full, true, and accurate copy or reproduction of that record in that individual's possession. It's in the individual's possession that's bringing it before you. And you'll see what I'm referring to in the notarial certificate wording. You don't know, if somebody brought you a public record like a driver's license or birth certificate, you don't actually know whether that's a true copy. You're not on the hook for that. But if I wanted a copy of something notarized as a true copy of another record, just got to make the copy of that, and you can see that it's the same thing. Again, I'm going to get into that in a second, but what I mean by that, what are we doing? Person's got to appear before you, got to identify them, make a journal entry, observe the signing of observe the copying of the record, or maybe it was already copied and they're just bringing it to you, right? And then you just look at that copy, look at the supposed original. Is it the same thing? Yep. You're going to complete and sign the notarial certificate, and the certificate is going to follow this page. It's also in the handbook. And you're going to apply your stamping device to the notarial certificate. What does this certificate look like? It is something that is certifying that's a true and correct copy of a record that is in someone's possession. In someone's possession. The person that is bringing you the record to be certified as a true copy. If I brought to you a copy of a record, it's a true copy, true and correct copy of a record that is in my, Michael Schlein's, possession. You're not saying it's a true copy of a driver's license or birth certificate or something like that. Just as a true copy of a record and something that's something in my possession. So you only know that it's in my possession because I'm the one that brought it to you, right? You don't know if it's truly a valid whatever it is. But you know it's a copy of something that I brought to you that's in my possession. So that's what this Notarial Act means. That's what it means. And you're completing that certificate. Again, what does it say? State of Maryland. All day. County of, wherever you're located. So this is the certificate, comes out of the handbook, comes out of the law. You know, a lot of folks, if they just need a copy of something notarized, they're just going to come to you and ask you to notarize their signature. I'm sure people do this Notarial Act. I don't see it I don't hear about it very often. The big three are acknowledgement, oath/affirmation, and witness/attest. We're not looking at every notarization ever performed, but we're not seeing a lot of this, right? Most folks are coming to you, they just want their signature notarized. Certifying a tangible copy of an electronic record. This would have never even needed to be a thing before, because you didn't really have a lot of electronic records running around. You certainly didn't have remotely notarized electronic records running around. But all that's happening here is that a notarial officer is certifying that a tangible copy of an electronic record is an accurate copy of the electronic record. When the notary is doing that, they're legally determining whether the electronic record is in a tamper-evident format and personally print or supervise the printing of the electronic record onto paper or other tangible medium. What is another tangible medium? I don't know, something other than paper that the record goes on. In all my years, I don't know that I've ever seen that. And we're not, that I know of, carving things in stone anymore, you know. So it's almost always on record, but other tangible mediums got to be there just in case it's something other than paper that's being used. So that's really all that's happening here, is the notary is saying, you know, and it's more likely that if you're asked to do this, you are probably the one that remotely or electronically notarized it, because you're going to be the one that knows that you did that. And you're going to be one that knows your technology is in a tamper-evident format. And if you remotely notarized it, you're going to be the one that has the electronic copy of that record that you could just print or supervise the printing of, right? It's most likely going to be that scenario. It's going to be a straight trade, you know, you did it electronically and eventually somebody wants it on paper. How does a notary public certify a tangible copy of electronic record? Step by step, right? Notice that theme here again on this page. Personal appearance, identify the person requesting the act, journal entry. Now here's where it differs. You're reasonably determining its electronic record in tamper-evident format. You're personally printing it or supervise the printing of it. You're going to attach the notarial certificate, most likely, to the tangible record. And that certificate is going to be here on the next page. It's also in the handbook. And that certificate is going to certify it's in a you know, accurate, you know, a tangible record that was an electronic record. You're going to apply your notary seal, your stamping device, whichever one you want to call it. Here's the short form certificate for certifying a tangible copy of electronic record. State of Maryland. State of Maryland. County of, wherever the Notarial Act is occurring. I certify this a true and correct copy of an electronic record entitled, whatever the title of electronic record is. Dated, date, month, year, containing however many number of pages. So whatever the date of that electronic record is. So that first line there is referring to the electronic record itself. That second line, dated the blank day, a blank month, blank year by, is today's date. Today's date. Name of the person presenting the tangible copy of the electronic record. Seal it, expiration, signature, notary public. So this is the certificate there. If you're not notarizing electronic records, I don't think you'll ever be asked to do this. Maybe I'm dead wrong, but I can't envision a scenario where you're asked to do this if you're not also the remote notary or the electronic notary. Protest of a negotiable instrument. I'm going to read a definition off. I don't really have good information on this type of notarial act. I've never seen a legit one done. More of an antiquated process or system, predating all this electronic e-commerce type of stuff that exists in today's world, this very interconnected world, where you can get anything at your fingertips from your computer or your phone if you have a smartphone. But it defines a protest as a certificate of dishonor made by a United States consul or vice consul or notary public. I just chuckle there because it's like, you know, which one doesn't fit? Or other person authorized to administer oaths by the law of the place where dishonor occurs. It may be made upon information satisfactory to that person. The person must identify the instrument and certify either that presentment has been made, or if not, the reason why it wasn't made. The protest may also certify that notice of dishonor. What's dishonor? How do you know where it occurred? If you don't know how to do this, don't do it. It's okay to say no if you don't know how to perform that type of notarial act. It has to be in the form prescribed by a comptroller. It talks about it more in the commercial law article. It's not even the section of the law that we regulate. State government article, Title 18. This is a whole other section of the annotated code. It's a protest is not required except upon dishonor of a draft, which is on its face appears to be drawn or payable outside of the United States and its territories and DC. That part I can put into English. A protest is not needed unless this has something to do with something that is either drawn from or payable to something that is not inside the United States of America. If it is in one of the 50 states or one of our country's territories and DC, protest cannot be used because it must be either drawn or payable outside of the United States, its territories, and the District of Columbia. So if it's in anywhere inside of land that is controlled by the U.S. Government, protest isn't needed. You see this related to, if more not than anything, kind of a sovereign citizen type of movement thing. I'm not going to go into depth of what that is, but if anybody wants to read up on that, go ahead. Where they don't necessarily believe that they're subject to the laws of the United States. I'll let you read more about it. That's all I'll say about that here. But it's not, you know, if you're drawn or payable from the United States or to the United States, or outside of the United States or from outside the United States, that's the only time somebody should ever be bringing you a protest. Again, I'm not looking at every document ever notarized, but I can tell you in all my years here, I've never seen a legit one done. Just kind of reviewing this information here. Notarial certificates is a lot of information in this town hall. I know that. If you need to rewatch it, watch this recording when it's posted later. If you didn't hear the phrase, the certificate always starts with state of Maryland enough, watch it later. That is, the notarial certificate is always required. Every notarial act that a notary public performs requires a notarial certificate. Knowing what an oath and affirmation is, witnessing and attesting signatures, what is an acknowledgement, know what those things are. Those are really the big three: oath/affirmation, witness/attest, or acknowledgement. Those three are probably the overwhelming majority of what you're going to be asked to notarize. One of those three. I bet it's probably over 90% of the time. It's going to be one of them three. Know what they are. I hope you have a better understanding of what they are after today. If you're kind of looking at it, wait, he said a lot of stuff fast. If you got a handbook, check on that handbook. Come back and consult the town hall later. But no oath/affirmation, no witness/attest, no acknowledgement. If you know those three, you'll get by almost everything. And again, all the stuff you can find straight out of the law. The certificates are straight out of the law. They're in the handbook, which is straight out of the law. The step-by-step instructions, straight out of the handbook. We try to organize that handbook to make it easier to read than the law sometimes. So the handbook is the step-by-step. The law doesn't really break it down like that, but the handbook does. It's a good tool to use. Refer to that thing. What I'm going to reference here too is all of our contact information. When in doubt, reach out to these things. Now I'm going to cheat a little bit. I'm actually going to change something real quick. That 5521 is the number to it's the main office line. It's not actually the notary division phone number. 5520 is the main notary line. 5520 is the main notary line. And it rings into our 3 notary officers. They will answer that call. It's only 3 of them. 3. 1, 2, 3. A lot of people think there's like a whole call center. I wish. That would be a great thing to have. 3 notary officers. Life happens. People call. You'll get somebody. If we got a chance to answer that call, we're going to answer it. We would rather be answering that call in real time rather than having to hope we get you on a call back. And if we don't answer, you can leave a message in that main notary division phone number, voicemail box. It's checked by our entire notary division. All of our notary officers are checking that, calling people back. Unless we're super short staffed, you're probably getting a call back that same or next day. It's very, very rare that call back is taken more than the same or next day, maybe a second day. If that's happening, we're probably very short. DL Notary _ SOS@maryland.gov. There is an underscore in there. DL Notary _ SOS@maryland.gov is the notary division's email address. You have a general notary question. Email DL Notary _ SOS@maryland.gov. That is the best way to guarantee a timely response. A lot of people went back to the town hall email address. We're really only checking it right before and right after town halls. So, we have that gap in the summertime. It's our first one back, where we're not really checking that town hall inbox except for around the time of town halls, because it's really only just for people who have questions specific to joining or, about the town hall where recorded stuff like that. So DL Notary _ SOS, these are your 2 best places to get good notary information. I know there's online chat forums and people say a lot of stuff there. If you're unsure, ask us. Maybe your authorized course of study and exam provider would be a good source of information to ask. I caution folks about just going to any random chat, because what you can do in Maryland may not be the same thing you can do as a notary in another state. Just may not be. Similar, probably, but not the same. There's some states where a notary can marry people. Can't do that in Maryland. Right? So get the information from the sources. we're a good place to start. Course of study provider, they're teaching you when you renew or when you first apply, and then later when you renew. And those courses explain all the stuff. When you take that course, pay good attention, please. Don't just click through it quickly to be done with it. Focus. It's a lot of different stuff than what it used to be. If you've been a notary for a long time and haven't really been in tune with all the changes in the law in the last 5 years, this town hall was probably an eye-opener because notary certificates attach it. What? Reach out to us when in doubt. Anybody can say anything on the internet. It doesn't make it true. I know deep down we all know that. But people tend to believe people when they say something, because why would somebody say something crazy or made up? Well, people do weird things sometimes. So know who you're getting your information from. Get it from a good source. Get it from somebody that does know. Feel free to reach out. If you know anything else, if you take anything else from today's town hall, we want to help you. If you're unsure, reach out. Phone, email. I'm going to leave this page up for a second in case anybody needs to write this down. Carrie Ann is going to read off many commonly asked questions. We're going to cover that. And then we'll wrap up the recorded part of this town hall. And if anybody wanted to stay on and chat for a few after that, we'll do that last. Carrie Ann has been monitoring that chat box. Carrie Ann, what do you have for me?
I would say that it was actually probably the nicest chat box I've ever had.
Congrats, guys. That's awesome.
It's off the hook. I actually have only 3 questions recorded, and then one came in at the very end.
Okay.
So I'll go back to that one. But Michelle Waller, doing an acknowledgement for someone as a representative, do we have the obligation to verify that they are the officer of the corporation?
The law is silent on that. It is silent on that. You have a couple options. It doesn't expressly say that you have to. Now, that person should probably be able to prove that easily, right? Like they should be able to. Common sense would dictate that. In a different town hall, we went into great detail about identifying signers and the methods of identification. And there's a nice little caveat at the end of the section where it says you got to positively identify somebody. And it allows you to require other information to verify their identity, to be satisfied with their identity. So if you want to ask for it, you can. The law does not say you have to, though. But yeah, you can. There is that protection in the identification section of the law that allows you to seek other information to satisfy yourself that they are who they claim to be. That's about as straight of an answer as I'll give on that. That's a really good question, though. Really good question. And as Carrie, before you read off the next one, I'm going to slide back to the very beginning where that links page was. If anybody wanted to jot down some links while we're chatting here before the recording, there's that links page up on your screen right now. What else you got for me, Carrie Ann?
All right, so I have Zena Swindell Smith.
All righty.
How do you know when to use the long versus the short form?
A really good question.
Okay, sure.
Really good question. You don't always know. Now, here is, my thought, kind of information to kind of help turn the gears a little bit on this. If there is a notarial certificate already attached to the document, that's the one you should probably go with, right? Because some probably really smart person or attorney has that typed up there, and you'll see acknowledged or oath or affirmation or witnessed, and it's going to have all those basic elements that those short form certificates that I shared have. Right? They're going to have all that at a minimum. So if that certificate is already on the document when you're being asked to notarize, use it. Use it. If it's a longer form, great. As long as it got those basic elements, you're good. If it doesn't have certificate wording already on the document, use the ones from the handbook. Use the ones from the law. Use the ones we showed here as examples of certificates, the shorter forms. Why do I say that? If you're not an attorney, well, maybe you are, but if you're not a licensed attorney, you don't want to give legal advice. You don't want to add things to a certificate that you don't know are or are not needed, right? So if it doesn't come on the document pre-typed or pre-printed, go with the short form certificates from the law and the handbook, because now you're just going exactly what out of the law says you need to do at a base level. Think of it that way. You don't have to know. If more is needed, it'll be there. It'll be there. And if it's not already pre-typed, the notarial certificate wording is not already on that document, go with what you do know, which is what the handbook and the law gives you for sample certificates. Think of it in that way, and you'll be fine.
All right, I got another one from Vita. Not sure how to say her last name.
Okay.
The question, is there such a certificate that fits all? One generic certificate?
Nope. There is not. The type of certificate that should be there, if it's already on the document, great. Great. It's already on the document. Go with that one. If it's not there, the type of certificate you're going to attach is determined by the request made by the signer. So if somebody just says, hey, I need you to notarize my signature, boom, official witness. Somebody says that they need it notarized and they, swearing to the truth of it, that's an oath or affirmation. If they're acknowledging it, acknowledgement. So it really comes down to their request. If there's not already certificate wording there that tells you what to do, you're going to do whatever the person requesting the Notarial Act tells/asks you to do. Pay attention to that request. All right. There are different Notarial Acts. I will say I've seen on rare occasion, probably counted on one hand, so it probably happens more than that, but not often, where I've seen a certificate that has both an acknowledgement and an affirmation, which are separate Notarial Acts. I've seen it. But you, the notary, shouldn't need to worry about compiling that or putting that together. You're going based on their request only. There's not a one-size-fits-all. It depends on what you're being asked to do as a notary as to what certificate should be there. And again, if the certificate wording is already there, that work's done for you. It's only when there is no certificate wording already appearing on the document that you got to figure that out. And you're going to figure that out based on what they request. What else we got, Carrie Ann?
All right, and this one I really like because I get this quite a bit. Sherry Arnold. If a person has already signed a document, doesn't say what kind of document, just signed a document, do they need to re-sign it in front of you?
Great question, Sherry, great question. I'm going to burn real quickly through the types of notarial acts because it depends on the act. What are you being asked to notarize? For an acknowledgement, it doesn't say subscribed or signed, it doesn't say signed or subscribed before you. It just says acknowledged before me. So for an acknowledgement, it could come pre-signed or they could sign it in front of you. If they sign it in front of you, they're acknowledging the record. If it's already signed, they're acknowledging the fact that they signed it and the record. If it's an oath or affirmation, what's that certificate wording say? Signed and sworn to before me. They have to sign that in front of you. So if something came with an oath or affirmation certificate on that document, or you were being asked to perform an oath or affirmation for them and you had to attach the certificate, they would need to re-sign it in front of you because that certificate is saying that they signed it before you. And then on the witness or attest, it depends, are you witnessing or attesting? If it's not signed and they sign it before you, you're going to say signed before me. If it's already signed before you, then that certificate needs to say attested before me. Because, I'm sorry, if it's signed before they appear before you. Ooh, running those words together. So it depends on what type of notarial act you are being asked to perform. When I talked earlier about the certificate wording is telling the story, every bit of that certificate wording is telling the story. If that certificate wording says signed before me anywhere in that certificate, they need to sign it in your presence, in front of you. You need to see them do it. And if it's pre-signed in that scenario, they just need to re-sign it while in front of you. If it doesn't say signed before me in the certificate, which an acknowledgement won't, or an attestation of a signature won't, then they can just attest to or acknowledge it, depending on which type of act you're being asked to perform. So it really does depend. It really does depend. That subtle detail or seemingly insignificant detail in this wording matters greatly. Every one of these words in this certificate has a meaning and a purpose for being there. State of Maryland, that's where you are. County of, that's where you're at when you're notarizing as well. Signed before me, they had to sign it before you, right? Or acknowledged before me, they acknowledged the record, or they acknowledged the record and the fact that they signed it in front of you. But it doesn't mean that they had to sign that in front of you because there's nothing that says signed before you. So it really does depend. So, think of it that way. That certificate, I don't know why I didn't say this earlier, that's like your instructions. If it's pre-typed on the document, if it shows up on the document before it comes to you, think of that certificate as your instructions on what you're doing as a notary. If it's not already there, all right, now you got to take their request. What did they ask you to do? Attach the certificate and then make sure that the certificate you attach accurately reflects what's happening. And if it says sign before you, they should sign before you. So you're right, Karen, it's a good question. The short answer is it depends. The longer answer, you just heard me go into detail about. Carrie Ann, any other questions you want me to tackle here before I wrap up, and then we move off recording to just general public Q&A?
None. From there was a lot of questions about needing a new handbook. I put up there a lot on where you purchased the handbook, and how often should I get a handbook, and those kind of questions where.
Yeah. So if Carrie Ann shared the link to get the handbook, it's actually a different division in our agency that sells the handbook. We don't sell our own handbook. Somebody else sells the notary handbook. The content we've made, but the actual sale and process of getting it to you is not something that's in our control, specifically in the notary division. Go to that page. How often should you get a new one? If you're paying attention to the law when it changes, or reading public notice on our website, when a law changes, we usually put something out there on our website to say that. If you read that, you can follow along as to what changed and kind of maybe just print it off and stick it in your handbook there at that point. Maybe you buy a new one. I don't like to give advice on how often you buy a new one because that costs you money. But when you're renewing your notary commission, there is a question on the app that asks if you understand the handbook. So you probably should have a handbook there. Do you need to buy it every time you renew? Maybe not. Maybe the law hasn't changed. The law didn't change for decades. From like the 50s until 2020, it was pretty much the same thing. with the exception of fees, which barely went up at that time. 2020, totally different law. If you haven't gotten a handbook in the last 5 years, you should get a handbook. It's way different than the old handbook. If you're using the old handbook from pre-October 1st, 2020, you're not notarizing correctly. So I guess I'd say it that way. It really depends on how often the law changes. The law has changed a few times in the last 5 years. Before that, it barely changed in like 50 to 70 years. So I'm sure we'll settle into a new norm, but you know, things do change over time. You know, in the last year and a half, the only thing that's really changed is regulation regarding what you can charge as a notary. You can charge more now than you used to be able to charge. I don't want to turn this into a conversation about notary fees, but you know, that's the biggest change in the last year and a half for you and what you're trying to do as a notary. You can charge more now. You know, it used to be $2, then it was $4, then it was $6, now it's $8. And so, you know, hopefully some of the changes will settle down. We'll find ourselves a new rhythm. But things change sometimes. So the legislature passes a new law, we get to enforce that. So yeah, I don't have a straight answer. I don't want to give a straight answer on purpose, but you know, if you got a really old handbook and it's from before October 1st, 2020, do yourself a favor, get a new one and then read it. All that stuff in the new handbook should have been covered in your course anyway, but that course will make a lot more sense if you renewed in the last 4 years, 5 years. That course will make way more sense with a new handbook in your hands. Yeah, I guess that's kind of it's a very long, rambly answer. But shout out Carrie Ann handling the chat box and everything. Thank you. Our notary officers in general, Carrie Ann, Marquita, Brianne, do good work. They work very hard to get you answers to your questions as quickly as possible. Sometimes we don't know the answer off the top of our head. We might have to check, and you might get a, hey, I'll get back to you, and that's fine. We will get back to you. We do mean it. You know, they turn around things very quickly overall. If you were very happy the last time you renewed because your app got approved fast, thank them. You know, new applications, all that stuff. They do a great job. They do great work. I just publicly say that. Carrie, and big shout out, especially for one of these town halls with me and making this happen. Just to kind of briefly go back over one more time, this recording, informational purposes only, not legal advice. This recording is going to get posted on the notary page of our website. That very first link on the page showing right now is the main notary page on our website. You should go there to find out notary information first. Participation here on this town hall was consent to the recording as per the email. This town hall is not the course of study for the purpose of renewing. Do get asked that question sometimes. It is not. Course of study talks about everything you need to know, not just notarial certificates and wording. Yeah, I just appreciate y'all taking time out of the day and joining us. And like I said, if you learn anything else from here, ask us questions if you have them. Reach out, dlnotary_sos@maryland.gov. Call us 410-974-5520. We're real people. Our notary officers are real people. If they do not catch your call, they will call you back. If they're not calling you back the same day, it probably means we got a ton of phone calls and we'll get back to you the next day. Rarely more than that. So thanks again. And again, town hall will be posted. The recording will be posted at that main notary page link, usually within a week of today, usually sooner than that, but within a week, it'll definitely be up there. Thanks for all you do as an officer of the state. And want to conclude the recording now, and then I'll hang on if anybody just wants to chat on the side for a few. I'll hang for a little bit. Thank you, everybody. Thank you. Thanks again, Carrie Ann, for making this happen with me.